This is functioning, I think.
Shall we start? Will request. Yes, shall we start, please? Yeah.
Permission to hold the dance.
Yes, please. Yes.
Is the mic on?
Am I audible?
Say something to testify.
Good afternoon, Your Lordships and Your
Perfect.
Ladyship. The Council acknowledges the gracious presence of the bench. However, for the sake of brevity of the proceedings, seeks the kind consent to collectively address the bench as Your Lordships. Much obliged. I am the counsel for the petitioner, which is Tintin Rights Collective, in the matter Tintin Rights Collective versus Republic of Tintin, under Article 32 of the Constitution. The council seeks permission to brief the facts of the case.
Please go ahead.
Much obliged. Your Lordships, recently it was revealed that in the capital city of Nachin, organized gangs are facilitating the trafficking of children into begging and some of them into prostitution. And these children are being exposed to heavy narcotic substances, which is impacting their health. In view of the same, the petitioner today has approached this honorable bench under Article 32 of the Constitution, seeking the enforcement of their fundamental rights, along with an interim relief for rehabilitation. A preliminary hearing was conducted, wherein the Attorney General and the Learned Solicitor General appeared and apprised the court of their views on the matter, after which the issues were framed and the matter was referred to the present bench. In light of these circumstances, there are 5 issues before this honorable bench today. I will be making 3 broad submissions and I will speak for a total of 22 minutes. First, I will be submitting how PILs should not be listed under generic cause-based titles. Second, how this court should not adopt judicial impact assessment as a thumb rule before considering the expansion of scope of Part 3. And third, I will elaborate on how the scope of Part 3 entails the rights of children begging on the streets. Following this, my co-counsel will deal with issue 4 and 5. If your lordships have no
Could we just receive the third issue once again?
I will elaborate on how the scope of Part 3 of the Constitution entails the rights of children begging on the street within its ambit. If your lordships have no preliminary queries, may I proceed with my first submission? Much obliged. Proceeding with the first submission, your lordships, it is submitted that PILs should not be listed under generic cause-based titles. Twofold arguments, your lordship. One, the existing guidelines on PILs are sufficient to curb the problem of frivolous PILs. And two, there is an adverse impact on bona fide petitioners if this happens. Your lordships, whether or not a petition is frivolous can be deciphered from the contents of the petition, the facts and circumstances forming the contents of the petition. This is because frivolous petitions would either have a superficial subject matter or they would be based on very less improper research that was conducted. Your lordship, if I was to draw your attention to certain existing guidelines that are already there and effectively deal with the problem of frivolous PILs. Therefore, your lordship, there are PI guidelines by this honorable court that was based on a 1988 decision, the 2013 Supreme Court rules, and the guidelines that were laid down in a 2010 case of State of Uttaranchal versus Balwant Singh Shoffel. All of these guidelines, your lordship, state that the credentials of the petitioner have to be checked. The content of the petition has to be checked. If there is a certain amount of public interest, that has to be checked. The degree of personal gain of the petitioner has to be checked. A sworn affidavit has to be submitted in the absence of personal gain in the petition. Your lordships, that means that all of these guidelines sufficiently state that when to deal with the problem of frivolous PILs, all of this has to be done before entertaining a PIL. Now, your lordships, if generic cause-based titles were to be adopted on the other hand, then in that case, your lordships, one, they would cause confusion because your lordships, when PILs are filed, for one, they are containing a lot many matters. For instance, even in the present case, we have a number of matters before this honorable bench today, that of child begging, that of child trafficking, that of prostitution and procedural technicalities. So how would generic cause-based titles comprehensively deal with the problem? And to your lordships, the intention of this honorable bench is to curb the problem of frivolous PILs, which is to say that publicity interest litigation should not come. Now, your lordships, even if the cause title of the petition was to be changed today, people who want to gain publicity out of filing PILs can still do that. We are in the digital age, and there are a lot many number of avenues in the print media and the social media to still go ahead and gain that publicity. Moving on to the second limb of my argument, your lordships, which is that this would have an adverse impact on the bona fide petitioners. Your lordships, notwithstanding that frivolous PILs do make their way into the courts, there are also recognized petitioners who have filed PILs that have brought about significant societal reforms, your lordships. There are prominent figures such as MC Mehta, Sheila Barse, Upendra Bakshi, and organizations such as Common Cause, PUCL, PUDR, who over the years filed petitions, and because they were so significant in the impact that they got that recognition and standing in the society. Now, this recognition and standing that they gained in the society, your lordship, helped both the judiciary and the society alike, your lordship. The judiciary was able to place trust in the PILs that were filed by these prominent figures, when in the initial days, the judiciary was apprehensive of anonymous letter petitions that were being filed. On the other hand, your lordship, as a matter of fact, PILs are a costly matter. And therefore, your lordships, this recognition has helped these petitioners in gaining that recognition, in gaining all of the resources that are important to file PILs, and therefore help the marginalized people in a much better way, your lordships. And with having argued the impact on bona fide petitioners and how generic cause-based titles do not solve the problem of publicity interest litigations, it is submitted that PIL should not be listed under generic cause-based titles.
Counsel, if you consider the existing practice for social action litigation, which is the term which Professor Bakshi prefers,
yes, Your Lordship.
What do you think is the existing framework in most of the high courts and the Supreme Court? Because if you're asking us to consider one of these two models, take a stance, right? What is the existing position?
To name it after the petitioner who is filing it, like any other writ petition, Your Lordship.
But what is the legal instrument? Is there any document which regulates this activity, or are we purely in the realm of common law here?
Your Lordships, PILs are filed like writ petitions only. There are only additional requirements for filing PILs, which are the PIL guidelines that state all of these requirements that have to be complied with while filing a PIL.
Is there any information available in the rules of practice?
Your Lordships, as far as I am aware,
particular High Court or the Supreme Court?
No, Your Lordship, as far as I am aware, there are not, Your Lordship.
So, Counsel, my question to you is, should the courts with their own respective administrative mechanisms
Yes, Your Lordship.
not retain the discretion in how they decide to consider PILs? Because PILs are not automatically listed before the judges.
Certainly, Your Lordship.
They would be staff members who look at the letter petitions.
Certainly, Your Lordship.
In some high courts, there are registrars who
Yes,
specifically look at them. And the judges who are dealing with them are dealing with them after many filters.
Yes, Your Lordship.
So is there any need for a court to sit as a 5-judge bench here and even look at this issue on the judicial side?
Certainly not, Your Lordship. Your Lordship, this issue was framed in the preliminary hearing, and the counsel is here to assist the court. And this issue was framed as to whether there is a need to start naming PILs in a different manner than as has been done to curb the.
What is the proper forum?
Sorry,
What would be the proper forum?
Your Lordship, since it is a procedural matter of PILs, the Supreme Court can deal with this matter, because the decision would impact the way all the courts in the country would start naming PILs if that were to be made a rule today.
So, could the parties also consider dealing with the respective chief justices or the honorable CJI on the administrative side?
Certainly, Your Lordship, but if the court decides today, then that can be taken up.
Now, counsel, look at the fact situation. Sorry.
Well, after.
See page 3, the first para.
Yes, sir.
There's a gentleman who says my name should be on the top because I filed the first matter.
Your Lordship, you're not audible.
I'm so sorry. So look at the third page, the first para.
Yes.
There's someone who says that my petition was filed the first.
Yes, Your
And
Lordship.
therefore that should be on the top.
Yes, Your Lordship.
Now look at a case where there is a very genuine cause.
Yes, Your Lordship.
But some of these fastest filers, they put together 2 newspaper reports and file a 3-page petition.
Yes, Your Lordship.
And say it is before the apex court, and the apex court says, we are not inclined, petition is dismissed.
Yes, Your
What happens to the cause? Because then the high courts would not intervene saying the Supreme Court has dismissed a PIL. Why should we get into this? So look at the other side.
Yes.
What are we promoting? What are we incentivating as a court? And why should we provide those incentives? And to reflect on the second part of your argument, you say that there are entities like PUDR, Common Cause, etc., or Mr. MC Mehta, Sheila Parsi, etc. All those who have done good work, they must be recognized.
Yes,
so when they come and argue in the court, they are of course recognized.
Certainly.
It is about whether the court understands who is a genuine PIL litigant
Certainly.
or is not, which the court is able to do.
Certainly.
But there are other ramifications when this court is forced to recognize that only because someone is filing the petition first, their name would be on the top and the reported judgment would go in their name. And therefore, that may have a lot of ill effects.
Certainly.
That was the issue that you had to address.
Certainly, Your Lordship. Your Lordship, the council has argued as to how even if generic cause-based titles were to be decided today as the solution, they would not serve the purpose of curbing frivolous PILs, Your Lordship. On the other hand, Your Lordships, the guidelines that are already in place, they comprehensively deal with this problem. So, Your Lordships, the 2013 Supreme Court...
Sorry, where in the Balwant Singh Chaufal guidelines is this issue dealt with?
Your Lordships, this issue, Your Lordships, so the case also talked about as to how frivolous PILs are making their way into the petition, because that case also said as to how someone who was going to be the Attorney General cannot be so because of the age factor. So it was about frivolous PILs, publicity PILs being filed on matters that would gain the petitioner publicity, Your Lordship. So ultimately, Your Lordship, frivolity comes down to the content of the petition, Your Lordship. The cause title alone would not help the court understand whether the petition is genuine or not, Your Lordship. So even though we say that that would dissuade fastest filers first, there's again a possibility of them gaining that publicity from other places, Your Lordship. That is why, Your Lordship, the guidelines that are already in place sufficiently deal that how do we deal with frivolous PILs making their way into the courts, which is to go through the content, ensure that it has a contention which is of public interest for in actual practice.
See, Counsel, we have one question. Okay, here is a petitioner who has come with sound research and data.
Yes, sir.
The cause is also genuine.
Yes, sir.
But the credentials of the petitioner is doubtful.
Yes, Your Lordship.
Possibly he or she has filed this petition for personal gains. What should be the approach of the court?
Your Lordship, that content of the petition, if all of these things will be factored in together, Your Lordship. So if, let's say, even if there's a petitioner who's a frivolous petitioner, but has filed on a petition that is of genuine cause, it's a well-researched petition, Your Lordship, and it focuses or it deals with a problem that is of significance, then the court can take it in, Your Lordship. And also, Your Lordship's PILs are filed all together. There are multiple PILs that will be bunched together and the court will hear. Ultimately, Your Lordship, the problem is that the petition is not frivolous because the content of the petition is well researched, Your Lordship. And so ultimately, if the issue is being heard, the court will be assisted in a proper manner, Your Lordship.
Counsel,
Yes, Your Lordship.
large chunk of PILs these days are not adversarial.
Yes, Your Lordship.
Just putting the word versus creates an atmosphere of adversariality
Yes, Your Lordship.
in something like this.
Yes, Your Lordship.
Don't you think it makes sense for us to remove the adversarial nature of some of this by just simply saying in re so and so?
Certainly, Your Lordship. But Your Lordship, I submit, Your Lordship, that the cause title of the petition would not change the nature of the petitions, Your Lordship. It has been...
No, it's not the nature of the petition.
Yes.
Just understand that.
Yes.
The question is, it's the nature of the proceeding,
Certainly.
right? When, say, question of night shelters,
Yes, Your Lordship.
or if you're talking about welfare of persons with disability,
Certainly.
government will come and say, we don't want to do this.
Certainly, Your Lordship.
Governments may come and say, look, these are our difficulties, let's find a way, this is what we can manage, this is what we'll monitor, this is what... All of those, the nature of the proceedings are not adversarial.
Certainly, Your Lordship.
Contents of the petition may be otherwise.
Certainly, Your Lordship.
For the court to get into the mindset and for the parties to get into the mindset, just putting A versus B, I think that is promoting adversariality when there is no need to be.
Certainly, Your Lordship, and I'm obliged to Your Lordship to bring up that point. But Your Lordship, the submission is that that even if cause titles have been titled as so, this is common knowledge that TIL is cooperative in nature, which means that that would not impact the way the nature of the petition is being perceived, Your Lordships, or change that now it is a cooperative petition in some sort of way. Because the court also acknowledges this, and so does the state. So when an interest is being brought before the court in matters of PIL, the state addresses that in those terms itself, that the way they can handle it, so much that they can do for the problem that has been brought before the court. So the submission is, Your Lordship, that the cause title would not necessarily have an impact on the nature of the proceedings
But you see, that is one internal. I'm giving you the external aspect of this.
Yes, Your Lordship.
You'd be familiar with a film like Kramer versus Kramer.
Yes.
That's right, which is in the public domain. And people, when they see versus,
Yes, yes.
assume that there is some level of adversarial nature. And that's true in most litigations,
Yes.
but not PIs. To give the public the idea
Yes.
that this should not be adversarial, that this is in fact something which we are all on the same page about. We're just trying to find a better way to move forward on this. I think it makes sense for this court to communicate to the public
Certainly.
that we are concerned with the issue
Yes.
and the cause and not the grievance of a certain person or a party.
Certainly, Your Lordship. Your Lordship, however, on the other hand, this is also about the identification of the parties, Your Lordship. So in a court, there is one party that is bringing the cause to you and the other party against whom that cause is being addressed, the duty that is being asked from them to be performed, Your Lordship. So in that manner, Your Lordship, the reason why cause titles are there in the first place is the identification of parties as well, Your Lordship.
Okay.
We'll go to the next point, please.
Certainly. Your Lordship, on the second submission, the argument is on the issue is on the conducting of judicial impact assessment as a thumb rule before considering expanding the scope of Part 3 of the Constitution. Your Lordships, I will submit two-pronged submissions on this. First, judicial impact assessments cannot be linked to the fundamental rights of a petitioner. And two, this exercise is an unfeasible exercise, Your Lordship. For my first submission, Your Lordship, fundamental rights are the cornerstones of our legal system. They provide such sacrosanct rights to an individual that in various cases, this Honorable Court has termed fundamental rights as inviolable, as transcendental, and these are so well entrenched in our Constitution that the enforcement of the same cannot be subjected to the capacity and resource constraints of the judiciary, Your Lordship. Further, Your Lordship, there fails to be an argument in favor of judicial impact assessment because the nature of fundamental rights is so that if today a right was granted, its immediate impact may not be accounted for. The ensuing litigation may start happening from years down the line, or it may start happening today and it may go on for a long period of time, Your Lordship. In which case, Your Lordship, I also move to my second submission to state that this is an unfeasible exercise, Your Lordship. Judicial impact assessment, in essence, is asking out of us the frequency with which these rights might be violated, Your Lordships. Now, to calculate that, a diverse range of skills would have to be at work, Your Lordships. And in our country, where there's already a lack of administrative resources and lack of data at the subordinate level, Your Lordships, this makes this exercise a time-consuming and a resource-intensive exercise. A comprehensive data would have to be conducted, legal surveys would have to be formed. And so, Your Lordship, all of this would lead to a delay in the enforcement of the fundamental rights of an individual, Your Lordships. And therefore, Your Lordships, a judicial impact assessment should not be conducted as a thumb rule before considering expansion of scope of Part 3.
Counsel, if I can just query you on that. So broadly, personally, I would be sympathetic to the argument that you're making, that trying to assess the impact on judicial resources, judicial infrastructure is perhaps not the best way of thinking about fundamental rights.
Yes.
But take the pragmatic view, right? Take the pragmatic view, which the respondents may or may not bring, that even when judges are interpreting rights in an expansive form,
Yes.
and the Indian judiciary has a long history of doing that, even when they are trying to create new rights or recognize new forms of remedy, is a bench not thinking about what sort of impact that order is going to have on, let's say, a socioeconomic rights claim?
Certainly.
So this may be different from what the literature is suggesting.
Certainly.
Because literature is taking the perspective of a lawmaker.
Yes.
A lawmaker who has to think about the introduction of new statutory remedies and what impact the introduction of the statutory remedy will have on how many judges you require, what would be the case flow.
Certainly, Your Lordship.
But in many ways, when let's say we take the example of how decisions are made about the sanction strength of the courts,
Certainly, Your Lordship.
something similar is already happening.
Certainly, Your Lordship.
So should we be taking such a strict stance, or should we be open to the possibility that this is an approach that should be explored?
Certainly, Your Lordship. Your Lordship, the Council submits that judicial impact assessment, as is being defined presently, is that the number of cases that would arise and the number of courts and judges and staff that would be required to handle that increased number of cases that have come up. And that is why, Your Lordship, the submission is restricted to that. Now, Your Lordship, as far as your question goes, which is to say that judiciary would already consider the feasibility of granting that right. Your Lordship, in cases where that is to be considered, the judiciary does consider that as one of the issues that would be framed in that matter. For instance, even in the same-sex marriage case, Your Lordship, the judiciary, before granting that right, is on its own considering whether it's feasible to grant that right or not, apart from...
But there's another level to it, which
Yes.
maybe I should have explained better.
Yes.
Even when we think about the expansion of rights, which are, let's say, in part 3,
Certainly.
which we are giving a higher pedestal, many of these rights become enforceable through statutory and administrative orders.
Certainly, Your Lordship.
So if you are making a practical distinction
Certainly.
between rights which are fundamental and reflect moral choices,
Certainly.
and hence we must not experiment with judicial impact assessment, then that argument may not apply with as much rigor, because you seem to be accepting that when it comes to the design of statutes or administrative orders, we can do the same.
Your Lordship, the argument is...
For instance, the right which is an issue, which your co-counsel will discuss, is
Yes.
basically, do the children who are homeless or who are begging also have a right of access to education?
Certainly, Your Lordship.
Now, that right cannot be fully mapped out or visualized with the constitutional language. It
Certainly.
requires reference to many statutes. So, administrative officials, legislators are making assessments.
Yes, Your Lordship.
I give you the simplest example. When the Union Law Ministry in India makes an assessment of how many judges should be there in the particular High Court,
Certainly.
they look at population data, they look at existing litigation rates, and then, of course, there is a process of consultation with the higher judiciary. So the basic debate here is whether that sort of planning can also be reflected in the way in which we think about the adjudication of socio-economic rights.
Your Lordships, 2 points on that. One, in this present matter, it is about the expansion of Part 3, which means that this is about recognizing a right that already exists but was inherently present in the fundamental right, Your Lordship. And 2, Your Lordship, that impact assessment cannot be linked as a thumb rule to my enforcement of my fundamental right, Your Lordship. So if I approach this Honorable Court today to enforce my fundamental right, but that is subjected to an assessment that would take certain amount of time, Your Lordship, that has an adverse impact on me. And since the...
I hope you see the long-term risk in the argument that you and I are endorsing right now, that if fundamental rights are not subject to such pragmatic limitations, very often courts may end up announcing newer remedies
Certainly.
and creating newer rights, which are very hard to enforce in the future.
Your Lordship,
That's actually going to create a criticism of the process itself.
certainly.
This is not something which the courts are saying.
Certainly.
Independent scholarship has been making this argument now for many decades.
Certainly, Your Lordship. Your Lordship, that capacity to assess whether the entities of the state have the capacity to grant rights to its individuals, Your Lordship, that should be there, that should be maintained. That is a duty of the state to ensure that as government and as judiciary, we are sufficient enough to deal with what is coming before us. But Your Lordship, it should not be made as a thumb rule that before you consider enforcing my fundamental right, you first conduct an assessment as to whether...
I think
Yes,
just to rephrase that,
yes, Your Lordship.
I don't think it's about enforcement of a fundamental right. It's about expansion.
Expansion, yes.
There's a huge difference there.
Yes, Your Lordship.
To me, as far as I'm concerned, a regular criminal appeal is also enforcing a fundamental right,
Yes.
which is Article 21, right? But tomorrow, if someone says that, not to be frivolous about it, that ACs in classrooms are also a fundamental right,
Certainly.
as the court, we should assess, can we as the court monitor the implementation, or can all the high courts, the Supreme Court of this country, monitor the implementation? Is that something which we have capacity for? Maybe, it's the government which best does it. If we were to declare this as a fundamental right, again, which is not found purely within the text of the Constitution, jurisprudence as it stands today. It's the expansion part. It's not just enforcement,
Certainly, Your Lordship.
right? Even, like I said, even a simple criminal appeal is also an enforcement of a fundamental right. It's only as a pragmatic limit, as my brother judge said,
Certainly.
that we as the judiciary should understand our limitations, because it is a zero-sum game. There are only so many judges, only so many hours in a day. If we are to say we are doing this instead of that, that is suffering,
Certainly.
right? So should we choose to do this? Maybe there is a good reason to do this. I don't think this court has such a lack of conscience that when we see a good reason to do this, that we will say, no, 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 no. We will never do this just because that other is better. So
Certainly.
in the context of expansion is what I'm asking you to answer.
Your Lordship, before I state my answer, can I seek an extension of my time since my time is up?
1 second. I think we'll permit her 10 minutes of extension. We have been asking her questions, so we'll give her 10 minutes. And please proceed.
Your Lordship, I stand corrected on my position that it is about the expansion of fundamental rights. Your Lordship, the answer to that is that I submit that whenever the feasibility of granting the right has to be checked, that can be done by the judiciary on a case-to-case basis. As I submitted to your Lordship's question as well before, that whenever the feasibility of granting that right, for instance, even in the same-sex marriage case is being considered, that would be considered by the judiciary on its own accord. But when we are interpreting judicial impact assessment to mean the capacity in the numerical sense of the judiciary, Your Lordship, that can be done independently. It's not a bad exercise, Your Lordship, because the capacity has to be there. But the council is submitting that it cannot be made as a thumb rule that my fundamental right is dependent upon whether the judiciary will be able to has the capacity to handle the resultant litigation of granting me that right, Your Lordship. That is.
Go to the next point, please.
Yes, Your Lordship. Moving to the third issue, Your Lordship, that I submit that Part 3 entails within its ambit the rights of children begging on the streets, and there lies a positive duty on the state to enforce these rights. Your Lordship's article, I will be dealing in this submission in a three-step argument. I will be dealing first Article 21, then Article 21A, and then Part 3 in its entirety. Your Lordship, Article 21 states, no person shall be deprived of his life or personal liberty except according to the procedure established by law. Your Lordship, this means that the right to life and liberty is guaranteed to all people in the Republic of Timtim, Your Lordships. And then it extends to the children found begging on the streets. Your Lordships, Article 21 has expanded over the years, and so all of the rights that have been recognized under Article 21, the right to life, the right to dignity without exploitation, and the fact that life means the basic necessities of life and more than mere animal existence, the children begging on the streets are entitled to all of these rights, Your Lordships. So they are very well covered under the ambit of Article 21 on a bare reading of the bare text, Your Lordship. Now, Your Lordships, fundamental rights as enshrined under Part 3 are not only negative rights as against the state, but they also constitute a positive obligation on the state to protect these rights. Article 21 does not state that the state will not deprive the person of his life or liberty. It says that no person shall be deprived of his life or liberty, Your Lordship. And so, Your Lordship, the state is under a duty to affirmatively protect the rights of a person under Article 21. The second limb of my submission, Your Lordship, is Article 21A, which flows from Article 21 and states that all children will be provided free and compulsory education, which are aged between 6 to 14 years, by the state. Now, Your Lordship, again, this article uses the term all children, implying that even those children begging on the street have the right to education and are entitled to free and compulsory education by the state. Your Lordship, this flows from 21, and it has been stated that there is a duty on the state to protect these children and ensure the children that this right is granted to them and is accessible by them. And Your Lordship, having established that Article 21A imposes a duty on the state to provide education, a reading of Article 45, which is a DPSP, which also states that the state has to strive to provide education for all children, including even those under 6 years of age. Therefore, Your Lordship, again, the duty of the state to provide education is created. And not allowing them this facility is a violation of the Article 21, the right that they have under Article 21. Proceeding to the last limb of my argument, Your Lordships, Part 3 in its entirety is available to all people. Certain rights are limited to the citizens of the state, but otherwise it is available to all people, all persons. And therefore, these children are undisputed beneficiaries of all the rights under Part 3. In Part 3, there are certain rights which are tailored specifically for children which are ridden with social evils. For instance, Article 23, which prohibits traffic in human beings and beggar and other forced labor. In the present case, Your Lordship, these children have been sourced, some of them have been sourced from immigrant camps. They have been trafficked. They are further being trafficked into prostitution and into begging, and they're being exploited for their for people's own financial gains. Further, Your Lordship, Article 24 of the Constitution, it prohibits the employment of children in hazardous forms of employment. And in the present case, the plight of these children is such that they're being administered very heavy doses of narcotic substances and their lifespans are being reduced. They are being forced to beg and most of them are kept away from their parents. Hazardous employment, Your Lordship, means that it is a work, it is a kind of a work that is likely to cause harm to the health, safety and morals of a child. Therefore, Your Lordships, these children's, their rights under Article 24 are also being violated. Now, Your Lordships, there is, if we see a equality, that Part 3 and Part 4 supplement each other. And so if Your Lordships were to observe articles under Part 4 as well, you would observe that Article 39E and 39F underscore the protection of children's health and well-being. They explicitly state that children should not be compelled to engage in occupations unsuitable for their age, ensuring the safeguarding of their childhood from exploitation. Your Lordship, again, in the case of People's Union for Democratic Rights versus Union of India of 1982, it was held that there is a primary obligation of the state to protect fundamental rights even in the absence of a legislation. Therefore, Your Lordships, it is humbly submitted that the scope of Part 3 of the Constitution, including Article 21 and 21A, extends to include within its ambits the rights of the children begging on the street.
Anything else? You have made all your points? Anything else you want to say?
No, Your Lordship.
All your points were made?
I have no query. I would invite my co-counsel.
Anybody wants to ask any questions? All right. Thank you
Much
so much.
obliged. It was an honor to argue before this.
Thank you.
bench.
Please.
Am I audible, Your Lordships?
Yes, please. Please go
Much
ahead.
Greetings to the bench. If Your Lordships have no queries in regards to the submissions made by my co-counsel, I seek your permission to move ahead and address the issue 4 and 5, Your Lordships. Much obliged, Your Lordships. In regards to the issue 4, I shall first establish that the scope of Article 21A allows for such a mandate, and then when in the context of rehabilitation, I shall then again establish that it is the constitutional duty of the state, first on account of Tim being a welfare state, and then secondly on account of international obligations of the country, Your Lordships. Firstly, Your Lordships, Article 21A provides that the state shall provide free and compulsory education to all the children in the age group of 6 to 14 years. Your Lordships, the word as is used in the provision itself, which is shall, indicates to the mandatory obligation on the state to ensure that no children in the specified age group are deprived of this right because of financial incapacity or any other reason, Your Lordships. Secondly, right to education, unlike other fundamental rights, needed an enabling legislation to be enforced, Your Lordships. In this light, the RTE Act of 2009 was enacted. While we delve into the particulars of the Act, the Section 8 of the Act, while defining compulsory education, lays down the duty for appropriate governments, Your Lordships. The Section 8 lays down that the duty of the state is to ensure A, compulsory admission, B, attendance, and then C, even the completion of the education. And in this line of argument, the Section 9 lays down the same duty for local government. The implication here, Your Lordship, is that the state's duty to provide free and compulsory education has to be read comprehensively and is not just limited to merely, let's say, curriculum development or infrastructure provision, whereas it necessitates that the admission is also seen to, the attendance is also seen to, and thereby also the completion is complied by the state, Your Lordship. Your Lordship, moreover, while we delve into the conversation of the rights of the children who are begging on the street, there are also certain other provisions that have to be kept in mind, such as the JJ Act of 2015 that defines these children as children who are in need and care of protection. Your Lordships, in the present case at hand, these children, more often so not, are trafficked into this organized crime. Therefore, they lack any capacity to assert their right themselves. They also lack any legal guardians to enforce their right for themselves. Therefore, Your Lordships, here, the responsibility of enforcing their rights falls squarely upon the state, and it becomes incumbent upon the state to assume the role of both a guardian and custodian of these children's rights, Your Lordships. With this, I move to the second limb of my argument.
Suppose we accept your contention and we want to give suitable directions to the government. How do we operationalize this? How do we ensure that the government takes the rights and provides the education? How do we ask the government to do so? Should there be some guidelines or should we just sweeping observations? What is your suggestion?
Certainly, Your Lordship. In context of your question, Your Lordship, first of all, there exists a certain legal framework which already provides that the state has to do a list of things so to ensure that the rights of these children are not violated and that they get the right to education. First of all, I believe, Your Lordships, that the state should be directed to comply by the existing legal framework, and if the need is felt that even the existing legal framework is not being able to sufficiently deal with the problem at hand, the court may direct as it deems fit, Your Lordship.
But counsel, as petitioners, if you're drawing our attention to existing statutory remedies, for instance, the Right of Children to Free and Compulsory Education Act, which is primarily directed at the state education departments, the district education officers to perform these duties, then what is the real case to come here in a writ petition and seek the same remedy? Because the impression that we got from the written submissions and from your co-counsel is that you want the court to engage in some judicial creativity. That is why we were engaging in a debate about social action litigation listing norms and also the possibility of judicial impact assessment.
Certainly, Your Lordship.
If the onus on you as a petitioner is to simply point out statutory remedies, then we are not very clear on what our role is here.
Certainly, Your Lordship. And I understand your concern as to regards of the burden of this right, which is very well established, that it is divided amongst the various stakeholders. This is a well settled position, Your Lordship. What the council here is trying to establish, as has been also pointed out by my co-counsel, that these are certain legal provisions that already exist, in the light of which the state necessarily has to do certain things. However, in light of the positive obligation that lies on the state, it also has to go beyond these and not just address the mere encroachment of these rights, but also to go beyond the encroachment and address the question of how the encroachment can be avoided in the first place and the right to education is ensured, Your Lordships.
But it seems like from your own submissions, a conjoint reading of the provisions in the Juvenile Justice Act and the Right to Education Act seem to cover the fact situation which has been brought to the court.
Certainly, Your Lordships. However, if I may point out that these provisions are already in place, and if they would have been complied well by the state as with the intent that they have been provided, the present issue would not have been arisen. Their rights would have been sufficiently dealt with. The present issue arises because the state has not sufficiently complied with them, Your Lordships.
So should we ask for compliance report? Is that what you're suggesting? Periodical compliances or something?
Certainly not, Your Lordship. What Your Lordship's direct is, it would be in accordance to your wisdom. What as counsel I'm submitting, that firstly, the state should at least comply by the legal provisions that are already in place, Your Lordships.
Counsel, as you're appearing for the Tim Collective, have they spoken to any of the children?
Sorry, Your Lordship, I could not.
Have your clients spoken to any of the children?
Your Lordship, the client has not
They
spoken.
have not. Have they spoken to the parents of the children?
Your Lordships, these children
Simple.
in a lot of cases do not even have parents, Your Lordship. I'm not aware as to the fact, Your Lordship.
We know for a fact that a lot of the children, their parents are in migrant camps and so on. You're asking us to direct the state to take these children away from their parents.
Certainly not your certainly not your Lordship.
Because-
the rehabilitation
Means what? Because in one sense, you're saying that the state should exercise its right of parents patria and basically become the parent of these children. State should take all the decisions for these children. Now, if tomorrow the state decides these children should not be in contact with their parents, they will say the Supreme Court has told us. Where do the parents go then?
certainly not your Lordship. First of all,
Counsel, you will not have a say in the process.
certainly your Lordship.
Will your clients have a say in the process? Do you realize what you're asking us to do?
Certainly, Your Lordship. But if I may, I would like to clarify that the term rehabilitation has to not be looked at the strictest of sense, which is to take away these children from the parents. First of all, it has to cater to the needs of the children who are on the streets, who, first of all, are in the organized crime, are trafficked into it, do not have any parents or legal guardians to deal with. And as the matter is concerned to the children who have parents and guardians, the state in that case may provide additional measures to them, as rehabilitation is a comprehensive term which also includes provision of education, skill development, Your Lordships.
Counsel, these are all big terms. We are judges. We are trained in the law. We have no idea how any of this has to be done. We will pass an order. The words will be there. End of the day, it's for the state to do it. We don't want our order to be the basis for a state to improve or perhaps worsen the lives of vulnerable children. Because maybe your clients, out of the goodness of their heart, have come here. We may say something out of the goodness of our hearts. But we cannot monitor on a day-to-day, minute-to-minute, hour-to-hour basis what is happening on the ground. So when you say rehabilitation, it has to be something so clear that there is no chance that somewhere along the way, the person who is worst affected is the victim of all of this.
Certainly.
So what is that rehabilitation you're talking about?
Certainly, Your Lordship. So the rehabilitation that the petitioner is seeking in that manner, Your Lordship, firstly is to rehabilitate the children who are, first of all, into the organized crime, do not have any legal guardians. So for them, the rehabilitation would mean that they are probably, if I may point out, in accordance to the provisions that exist, probably are kept in observation homes or similar mechanisms, Your Lordship.
Counsel, you're asking the government to detain these children.
No,
Because when you say kept in observation homes, they're not invited there on a voluntary basis.
Certainly.
You have used the term kept in. That is essentially detention. Those are detention for children. So please be very clear. What are you asking us to do?
Certainly, Your Lordship. The phrase that was used by the council was merely to derive an analogy as to the current legal framework that exists. When the issue or when the direction is passed by, the mechanism as to what has to be specifically done shall be sufficiently dealt with, and there shall exist certain measures and strict measures as to what should be done. It was just to merely derive an analogy, Your Lordship.
Suppose we were to involve your organization in observing these modalities, could your organization be ready? If we were to involve your organization, whom you are representing, in helping the government to implement these things, would your organization be willing to?
Certainly, Your Lordship, certainly. The organization feels passionately for the cause.
And as a council, will you also render your service for that?
Certainly, Your Lordship, that goes without a question. The council and the organization feels passionately about the cause and is cognizant of the plight of these children.
Counsel, as a worthy counsel of this court, please assist us. There's a dilemma here. You see a family which is begging in the streets, father, mother, and children. And then you want us to grant you the fourth prayer that all children who are in this should be rehabilitated. How would that order be effectuated? So would you have police personnel go snatch that child from the parents who are already on streets and put them in schools and then otherwise some observation homes? How would this order be effectuated?
Certainly, Your Lordship. To answer your question, the term rehabilitation in the strictest sense, to let's say pick them up from the streets and put them in whatever direction as is passed by the court, would be for children who do not have any legal guardians or parents, Your Lordships. In the case that these children have families who all are on the streets and beg together, the rehabilitation for them would mean to provide them with the measures so as to empower them, so as to eradicate poverty, and that they do not beg. And
As a worthy counsel of this court, do you believe that this court has the wherewithal to get into such questions, say as generic as to eradicate poverty?
certainly not, Your Lordship.
We would wish to, but are we capable?
Certainly not your, the submission is not in regards to that, Your Lordship. The submission here remains in terms of rehabilitation. To answer your question, which is the second part of the question in terms of children who are begging on the streets, who have families, the rehabilitation would mean to provide them with skill development measures, Your Lordship, to provide them with educational opportunities so that their right, as is enshrined in Article 21A, is realized in the fullest form, Your Lordship. Sorry.
Please proceed.
Now I move to my second limb of the argument, which is in regards to rehabilitation, where I firstly established that if your lordships would refer to the Moot proposition itself, the very first few things that define the Republic of Timtim is that it is a welfare state. Now, a welfare state can be restrictively defined as a system of government that ensures economic and social justice for its people and uses its resources to this end. Your Lordship, this has also been very well provided for in the Article 38 of the Constitution. Your Lordship, here the petitioner is submitting that since Republic of Timtim is a welfare state, it has certain duty of rehabilitating these children, as the courts of this country have very well recognized the important role of the state as a welfare state, and has also acknowledged that rehabilitation is an important welfare measure, Your Lordships. If your lordships may allow, I would point out two certain case laws that have discussed the importance of rehabilitation in that line, your lordships. Firstly, in the case of Neerja Chaudhary versus State of Madhya Pradesh, there was the order of identification and release of child laborers was there, your lordships. However, they were not rehabilitated. In this case, the court acknowledges this and underscores the importance of rehabilitation and says that even their release would not mean anything if they are not rehabilitated sufficiently, and they would still be left in a helpless and impoverished state, your lordship. In this line of argument, in the case of MC Mehta versus state of Tamil Nadu, there were, again, the importance of rehabilitation was accounted for by the court. And the measure that was herein appointed was that there was creation of a child labor rehabilitation come welfare fund, your lordships. Moving to the second part of my argument, your lordships, I discuss the international obligations that make it necessary for the state to rehabilitate, your lordship. At the international level, the international legal instruments that deal with child rights and children's right to education are majorly ICESCR, CRC, ILO. And within a paragraph, I will quickly summarize how these three major international instruments as well provide for the state's duty to rehabilitate, your lordship. Firstly, ICESCR provides for the right to education of these children in the Articles 13 and 14, and it provides that this right to education has to be enforced by using a specific mechanism, which is the framework of 4 A's, which means that the right to education, to be a meaningful right, should be available, accessible, acceptable, and adaptable. Therefore, in this light, it becomes incumbent upon the state to take special efforts so as to ensure that this right to education is ensured in the present framework, your lordship. Secondly, the CRC obliges the state to firstly ensure the child's best interest in any matter concerning children, your lordships. And specifically, the Article 19 and 13 provide for that the state protects children from all forms of abuse and neglect, and provide for appropriate assistance for physical and mental recovery by social reintegration, Your Lordship.
Counsel, what is the status of CRC vis-a-vis our country?
Your Lordship's Republic of Tim Tim has ratified the same.
It has been ratified. There
Certainly.
must be some legislation that brings it into effect.
Uh,
Post ratification.
Your Lordship, as was held in the case of Vishaka versus State of Rajasthan, even the international law, if it is consistent with the municipal law, it can be considered by the court to expand the scope and to hold the state accountable. In this light, it is submitted that the CRC provides for protection from abuse and neglect and for mental and physical recovery. And this law is consistent with the present legal framework that the country has, which is in light of, let's say, JJ Act, the NCPCR Act, and further, Your Lordships.
Very good.
Lastly, Your Lordships, there exists ILO, which has, in its convention number 18296, has established that street begging falls in the category of hazardous labor, and that the state should provide for that. This is not happening, Your Lordship. With this, Your Lordship, I seek your permission to move to my last issue, Your Lordship. For the convenience of Your Lordships, in regards to the fifth issue, the Council shall first establish that the judiciary has the authority to intervene to legalize prostitution in accordance to Article 142, Your Lordships, and then secondly establish that Republic of Tim Tim follows the common law tradition which empowers the judiciary to intervene in this matter, Your Lordship. Firstly, the clause 1 of Article 142 provides that the Supreme Court may pass any decree, make any order to administer complete justice in situations where there is a lack of law or where there is a lacuna in the legal framework, as has been also identified in the case of Kalyan Chandra Sarkar versus Rakesh Ranjan, Your Lordships. To understand the entire scope of the judiciary's power under Article 142, the Council shall further submit that there exists a lacuna in the current legal framework and then establish how the fundamental rights of these sex workers are being violated, Your Lordships. Firstly, the current provisions that deal with prostitution are ambiguous. They acknowledge and deal with certain facets of prostitution. However, they are silent on other facets of prostitution, which renders to the effect that these sex workers end up facing penal repercussions under these laws, Your Lordships. In this light, I would like to highlight certain provisions, Your Lordship. Firstly, Clause 1 of Article 23 prohibits trafficking of human beings, including sex trafficking in context of prostitution. And the Clause 2 of the same penalizes for the same, Your Lordships. Thereby, the entire scheme of this article only addresses forced prostitution and does not account for independent sex work or sex workers who voluntarily engage in this work, Your Lordship, for financial gain or otherwise. Your Lordship, I seek an extension of 5 minutes to quickly summarize.
7 minutes more.
Yes.
So you've been asking questions too.
Yes, please.
Much obliged.
You have 7 minutes more, all right?
Much obliged, Your Lordship. Further, Your Lordship, there exists ITPA 1956, which doesn't necessarily inherently criminalizes prostitution, but however, it encompasses other activities such as running brothels or living of earnings from prostitution, due to which the sex workers here again who engage in consensual sexual relationships privately end up facing legal repercussions under this act. Lastly, Your Lordship, there is Trafficking of Persons Prevention, Protection and Rehabilitation Bill, which adheres to the definition of trafficking of persons from the Section 370 of IPC. Now, the nature of the Section 370 of IPC is such that it is very broad and it has an expansive language, which can very well be interpreted to include sex work by framing it as a means of coercion or inducement, Your Lordships. Your Lordships, by highlighting these provisions and putting forward them to the bench, the Council submits that the present legal framework does not sufficiently deal with sex workers who voluntarily engage in this act, and therefore there exists.
So let me clarify 2 concepts here. If something is not punishable as an offense or prohibited by any other law, it is legal. On a plain reading of a legislation, consensual sex work is not penalized, right?
Certainly, Your Lordship.
We can say all we want to, we cannot prevent misuse of law. There is no judgment in the world which can say this law will not, I mean, it can say it, but it will just be words, right? We cannot say that. That's a different measure. Second is regulation. Regulation is where the state is getting into the picture to say this is how these set of acts should be done. What do we need to legalize here? Are you asking for an interpretation which nobody else disputes? It may be vague to you, but maybe on the ground, 99 out of 100 cases, they say, yeah, it's fine. Maybe you are only seeing the one case where someone is abusing the law and bringing sex workers into the legal net. What are we legalizing is I'm not still clear on this point.
Certainly, Your Lordship. I understand your consideration, and I would like to highlight the regulatory gap that the council is submitting is in regards to independent sex work and not.
What is, do you want us to ask the government to set up a body to regulate sex work?
And to legalize it, Your Lordship.
What is the need to legalize it? It is legal.
Your Lordship, the plain reading, as also mentioned by you, does not inherently criminalizes prostitution, as the council also acknowledges the same. However, the present condition of these legal provisions is such that there is an encroachment and continuous violation of fundamental rights of these sex workers, which is the second limb of my
By whom?
which
By whom? Who is violating?
Your Lordship, the necessary parties are not identified in this case, as the council is submitting the present case.
Council, this is not a pure academic debate.
Certainly, Your.
We are hearing a case because there are individuals, persons who are violating someone's right, but they're not supposed to. We need to know who's violating. The case is not about interpreted this way, interpreted that way. It serves a purpose to grant a relief.
So,
For us to grant the relief, please tell us what is the right being affected, who is violating or who is not carrying out their duty to ensure that this right is seen in
Your
place.
Lordship. Firstly, Your Lordship, in regards to violation, the argument remains the same, which the council for the petitioners have been submitting from the very beginning, which is that even in absence of absolute parties that are violating the fundamental right, it is still the duty of the state to.
It doesn't have to be parties. Identify on facts who is violating the right.
Certainly, Your Lordship. Your Lordship, in certain cases, it can be said that the state is also violating these rights because it is not providing them with the sufficient mechanism and measures to realize their right, Your Lordship. So for, let's say, for example, there exists Article 19(1)(g), which provides for freedom of profession, Your Lordships, and this profession of sex work has also been identified by the Supreme Court, Your Lordship. However, due to the current legal framework that the council has already established, Your Lordship, and probably the moral judgment that the society sees it with, they end up in a situation where they cannot enjoy this right, Your Lordship. And Your Lordship, the restriction that is present in the case is not reasonable, Your Lordship.
What is your suggestion? What concrete measures should be taken? Can you make suggestions? What should we ask the government to do?
Your Lordship, if I may point so, the state can first initiate by legalizing prostitution, for which the petitioner here in this case is the state hasn't been able to do so, even when the matter has been with the state for so many years, and it has still not sufficiently dealt with it. Therefore, the council today is submitting that the judiciary intervenes in it in this matter, Your Lordship.
Probably one way of saying is that stop the authorities from harassing these people whom they are carrying on their vacation. It is not illegal. They are being bothered and they are being harassed. That could be one suggestion, are you saying?
Certainly, Your Lordship. Now, I quickly summarize the last limb of my argument as I'm running out of time, Your Lordships. The last
Also,
argument.
just before you close, so are you asking us to interpret rights here or just think about remedies on this last issue?
Your Lordship, the interpretation and the remedies, Your Lordship. Firstly, the term that we're asking for, the remedy that we're asking for is legalization of prostitution, and Your Lordships may do it in the way that they deem fit, Your Lordships.
But not to interfere with the existing legislation.
Your Lordship,
Trafficking Prevention Act, you want us to leave that aside?
Certainly, that is not the suggestion, Your Lordship. If Your Lordships feel by the submission of the council that they are not in consonance with the constitution, they may also choose to do with them as they deem.
Council, I was going through your submissions, the written submissions, and there is in fact a Article 19(1)(g) jurisprudence on what sort of professions or activities can be brought within the realm of rights-based protection, which ones are not. And our predecessors on the bench have actually been quite analytical about this
Certainly.
in terms of using doctrines like res extra commercium or balancing the 19(1)(g) interest with other grounds. So perhaps that argument could have been fleshed out, which I could not really see clearly in your written submissions.
Your Lordship, I could not understand the.
If you want us to use, for instance, 19(1)(g) to say that the freedom to pursue profession, occupation, trade or business is one way out, because ultimately you want us to recognize the right,
Certainly, Your
which
Lordship.
can be used to protect the interests of sex workers, irrespective of the context in which it happens. But in terms of the existing jurisprudence on Article 19(1)(g), there is a long line of case law
Certainly, Your Lordship.
which has dealt with these issues.
Certainly, Your Lordships. However, in this submission, the matter is in regards that even despite the jurisprudence that exists and the explicit rights, the explicit right that exists, the encroachment and infringement of this fundamental right is still happening for these sex workers, Your Lordship.
Yes, please, of course. Please.
What is the way in which the petitioners asked for the bill? And what is the way in which your prayer was drafted? Can you be more specific? Because in the Nalsar decision, what was the relief that was claimed?
Just a moment, Your Lordship.
Can you go and get it back to us?
Yes, in the rejoinder, just remember this question. Please note it down. When you have a right to rejoin,
Certainly.
please enlighten us on that. Now, we'll give 2 minutes to sum up, please. Will that be sufficient?
Yes, certainly.
Yes, please.
Certainly, Your Lordship. Your Lordship, my last submission being that the Republic of Timtim follows the common law tradition, which assigns a significant role to judiciary to not only interpret laws in the strictest of sense or the traditional role of dispute resolving, but also to ensure that the present laws are in consonance with the social changes and the contemporary times, Your Lordship. Therefore, in this case, where the matter of prostitution was open for the legislature to legalize and regulate upon for so many years, it has still failed to do so, which is leading to violation of fundamental rights of these sex workers. It is incumbent upon judiciary to step in and legalize and regulate on this matter, Your Lordship. Much obliged, Your Lordship.
Thank you so much.
If Your Lordships allow, I seek your permission to pray before Your Lordships.
Thank you.
Much obliged.
It's not required.
Oh,
I think because it's just a repetition of the remedy, I think
Thank
it will
you.
be required.
much obliged, Your Lordship. It was an honor arguing before
Thank
the
you.
bench.
Thank you, Council.
You have been very patient. This is not what typically happens in prayer, okay?
So sorry, Your Lordship, I didn't.
You have been very patient, waiting for your prayer. This is not always happens in the court.
Yes, Your Lordship. If I may begin with the permission of the bench. Am I audible to the bench?
Please test the sound once.
Good evening. Am I audible?
Much better.
Good evening, Lordships. I, along with my co-counsel, will be representing the respondent, which is the state, in the case the Timtim Rights Collective versus the Union of Timtim. The Lordships, as the petitioners have rightly highlighted, there are 5 issues in the present case before us. I will be taking up the first 3 issues, devoting 21 minutes of my time, while my co-counsel takes up the next 2 issues, devoting 21 minutes of his time, and we reserve 3 minutes for star rebuttals. Your Lordships, before I proceed into the merits of my submissions, I'd like to highlight and divert this courtroom's attention to 2 important facets of this entire adjudication process. Firstly, Your Lordships, while the petitioners have placed their prayers on record, I'd like to highlight one important fact that they must be cognizant of the reality that the union cannot adopt a one-dimensional approach. While recognizing the importance and delicacy of the matter that we're dealing with, it has to be recognized that the union cannot adopt a one-dimensional approach, considering the fact that the union is responsible for catering to a wide array of interests and administering a wide array of affairs, and therefore their capacity and their resource constraint must be kept in mind while the petitioners plea before this honorable court. Secondly, Your Lordships, throughout the process of this hearing, we aim to act as officers of this Honorable Court and aim to assist this court in finding a solution to this social problem that has arisen before us and don't mean to in any way be adversarial in the proceedings. With that, Your Lordships, I seek your permission to proceed with issue number 1. Under the first issue, Your Lordships, our primary submission is that the current petition is not maintainable under Article 32 of the Constitution, and that petitions must be listed in a generic cause-based title manner as opposed to a fastest filer's first manner. With respect to the first limb of our argument, Your Lordship, I seek to refute the maintainability of this petition on the grounds that the petitioners have failed to exhaust an alternative remedy which is equally efficacious to the one sought by them. Your Lordship, there are two remedies in this case. Firstly, I refer to the remedy that they have before the High Court, which has jurisdiction over the territory of Natchin. Your Lordships, if I may direct your attention to paragraph 4 and 5 of the Moot proposition, it is clear to us, with the facts that are given to us, that the determinate class of children whose rights the petitioners seek to enforce are within the territory of Natchin, and even those sourced from the immigrant camps are from within the territory of Natchin, and therefore, the High Court, which holds jurisdiction over the said territory, would be an equally efficacious remedy to grant the relief that the petitioners seek before this Honorable Court. Secondly, Your Lordships, as the petitioners have also recognized, the petitioners have a statutory remedy of rehabilitation and education in the form of the Juvenile Justice Act, specifically Section 31 and 53 of the Juvenile Justice Act, Your Lordship, which they have failed to exhaust before approaching this Honorable Court.
Sorry, what's the specific remedy? What can they do under the Juvenile Justice Act?
Your Lordship, they can approach the various child welfare committees set up in different districts under the Juvenile Justice Act and produce these children before them. And from there on, the child welfare committees with the various child protective homes under their jurisdiction undertake the rehabilitation process in consonance with Section 53.
What is the locus standi requirements of appearing before the child welfare committee?
The locus standi, Your Lordship, I believe the petitioners have to, the children that the petitioners seek to produce before the child welfare committees must meet the definition of children in need of care.
Point is, they should have the children in their custody.
Yes, Your Lordship.
They don't.
Yes.
So how can they have locus standi?
We understand, Your Lordship. We contend that the fact that they haven't even attempted to exercise this remedy under the Juvenile Justice Act.
Counsel, please follow the question. If children have been rescued and brought under state authority, then the Child Welfare Committee can look at whether their children in need of care and protection. Then the respective Child Welfare Committees could include orders such as enrollment in school.
I understand, Your Lordship.
So there is also an empirical problem in addition to what my learned justice is saying, right? You're asking the petitioners to go to multiple districts to solve a problem which can be addressed through writ here.
I understand, Your Lordship, which is why we contend that the first alternative remedy that they must have exercised is the High Court, which has jurisdiction over Natchin. We concede that the statutory remedy may be held as not equally efficacious, which is why our primary submission is that the petitioners must and should have approached the High Court before approaching the Honorable Court in this present matter, Your Lordship.
One larger question. When a citizen comes for enforcement of fundamental rights, is an alternative remedy a ground to reject the request?
Your Lordship,
Would that be so? Is there any case law on that, or are you aware of?
Your Lordship, I do understand that this is not a matter of rule, but a matter of discretion before this Honorable Court. However, in the past, the Honorable Court, with respect to case laws, a couple of case laws that come to my mind are firstly Kanubai Brahmbhatt versus State of Gujarat and Balko versus Union of India, wherein the court held that although this isn't a matter of rule, the fact that an alternative remedy exists and the petitioners have failed to exhaust that remedy before approaching the Supreme Court would be a ground to refute the maintainability of the petition under the article, Your Lordship.
Counsel, just to add to that line of questioning, most of those precedents deal with identifiable parties have had disputes starting in lower forums, be it judicial forums or tribunals. So to apply the exhaustion of remedies doctrine in a dispute which is fundamentally between identifiable parties is a very different situation in comparison to the present one, where essentially we are talking about homeless children, abandoned children, forced into begging, right, who will not be essentially part of an identifiable party. That was the point of having encouraged social action litigation.
And I understand your lordship. However, the same relief that has been sought by the petitioners with respect to the class of persons whose rights are seeking to enforce in the manner of the children that your lordship just mentioned, we contend that the High Court also has the powers to issue the directions and issue the relief that the petitioners are seeking and therefore would qualify as a remedy which is equally efficacious in the present case, which is why we contend that only keeping that factor in mind, the existing nature of an alternative remedy can be a possible grounds for refuting the maintainability of this petition by this honorable court, your lordships.
And how would you deal with the problem of migrants amongst these children?
Your lordship,
Migrants may mean some children are from originally from other states. Some children may in fact be from neighboring countries.
I understand.
How does the High Court deal with those situations?
I understand your lordship. However, the fact that the exploitation of the children and essentially the activities which have led to the deprivation of their rights have occurred within the territory of Natchin, and through Article 226 it is clear that the jurisdiction of High Court extends to occurrences that take place within the territorial jurisdiction of the High Court, which would extend to the boundaries of Natchin, wherein the exploitation has taken place. Yes,
Counsel, by what the petitioners are arguing includes interaction not just with compulsory school enrollments, but also interaction with parents in case of children who are abandoned. So it did not necessarily make it a national issue. The problem of begging may be concentrated in some commercially developed areas, but the socio-economic response or the legal response is spread across states.
I understand your lordship, but the specific prayer of rehabilitation and mandating the education is well within the mandate of the state government, who can be directed by the High Court, to whom we are requesting the petitioners to have taken recourse to before approaching this honorable court, your lordship. Therefore, I do understand that the directions passed by the court may include a pan-nation connotation to it. However, when we look at the mere prayer of the petitioner, they essentially pray for the rehabilitation and mandated education of these children, which is something that falls well within the mandate and the jurisdiction of the High Court, which has again jurisdiction over the territory of Natchin, your lordship.
All right, we'll consider. Yes, please.
Your lordship, the next limb of my argument under issue number 1 is that petitions must be listed in a generic cause-based title manner as opposed to a fastest filer's first manner. Your lordship, we contend that a fastest filer's first manner would encourage frivolous petitions, as it incentivizes petitioners to ensure that their petition is filed only with the intention of them being the first persons to do so, as opposed to doing it with thorough and detailed research backing it. As opposed to this, a generic cause-based title manner would club petitions of a similar subject matter together and name them under the generic cause, and therefore would take away this incentive of having petitioner's name listed on the top, and therefore would take away the incentive of having their petition filed first with sheer disregard to the need to conduct a thorough and detailed research. Therefore, to that effect, we refute the contentions made by the petitioner and argue to the opposite, that adopting a generic cause-based title manner would actually encourage genuine and bona fide petitions and discourage frivolous PILs, which have been increasing in the last couple of years, in the last decade, your lordship. With permission of your lordships, I'd like to proceed to issue number.
One question.
Yes, your lordship.
Mr. Madhav Lal Verma may be the, let's say, responsible party. Why are we punishing them?
Your lordships, we aren't punishing them as such. This question has arisen before us.
You've said frivolous sounds like a bad thing. Now you're saying you want to deter that. But now it means their name also won't be on the cause title. Why are they suffering the consequences for Mr. Verma's misdeeds, shall we say?
Your lordship, if I may revert back to the petitioner's contentions, they have made it very clear that they
I want to go to petitioner's contention. I want to understand why you think removing the names of even genuine PIL, and you're not saying that they're not genuine PIL petitions. How does that deter frivolous petitions?
Your lordship, with regard to the first part of your question, the intention behind a genuine petition is to espouse the public interest that they're espousing in the petition. The intention is to gain the relief that they seek with respect to that petition. Therefore, whether or not the petition has their name listed on top, the fact that the court is adjudicating on the relief that is prayed by them before this honorable court is satisfactorily not amounting to a punishment to them. With respect to the deterrence question, your lordship, of course, if we adopt a generic cause-based title manner, then even genuine and bona fide petitioner wouldn't have their name listed. However, yes, your lordship.
No, counsel, what I'm saying is, see, there's a distinction. There are a lot of cases where this court suo motu takes up some issues. And in those cases, it's very clear that this court is taking up those issues in recognition of the fact that there are parties who have put in effort, time, energy, and even whatever money that takes to do all of this. They're saying let their names be on the cause list. We will, as a matter of internal practice, say not include the likes of Mr. Verma or whoever else it is who's trying to get a little bit of publicity of it. So we're recognizing their efforts. Can we not recognize their efforts as a court?
Answer, Your Lordship. So, two-part answer to that. Firstly, the current guidelines, as espoused by the Balwant Singh Shawfal case, Guideline 6 gives the Supreme Court the jurisdiction, the discretion to determine the relative urgency and importance of the petitions listed before them.
It's all great. My point is very simple. If we want to recognize their efforts by having their name on the cause title to describe and the lead petitioner in this particular case, is that necessarily a bad thing?
Your Lordship, it isn't a bad thing by any means. However, we believe that when a petitioner espouses a genuine and bona fide petition, as the Supreme Court has reiterated many times, the intention behind that petition is to espouse the public interest that they are seeking, is to gain the relief that they are seeking, not for their names to be listed on top of the petition.
But we are saying, as a court, we want to encourage good-hearted, hardworking, thoughtful people to come to this court. And therefore, we will put your name up. Of course, the cause is going to be different and we will decide. But this is the point.
I understand, Your Lordship. However, considering the contrary, if a fastest filer first system is adopted, even then the recognition of the efforts by genuine and bona fide petitioners isn't something that is granted, because the petitioner who filed their petition first, their name would be listed on top essentially, and there is no guarantee as regards to the bona fide or mala-fide intention of their petitions. Therefore, when weighing between a fastest filers first and a generic cause-based title, while both might have their upsides and downsides, one of the downsides being that maybe the court would like to give certain recognition which it would be unable to. However, when we weigh the two options, we contend that it is a generic cause-based title which meets the cause and intention of this court in a much better manner, Your Lordships. All right.
So, is it permissible under the court rules to list the matter without the cause title?
I'm so sorry, Your Lordship.
Is it permissible under the existing court rules to list a matter by removing its cause title or changing its cause title?
Your Lordship, under the current rules, as the petitioners also contended, the petitions are listed in terms of the names of the petitioner and the responding parties. The courts merely have the discretion to determine which matter is more urgent or which matter is more important in their opinion, and prioritize the hearing of that matter over the other matters. Therefore, we contend that the current guidelines, although are sufficient in terms of the discretion granted to the courts, they are still not sufficient enough to discourage frivolous petitions, as the Supreme Court has recognized multiple times in the last few years that the magnitude of frivolous petitions has been increasing exponentially regardless. Therefore, we contend that a minor tweak in the guidelines to this effect is something that would serve the purpose of this honorable
Asking us to legislate. As respondents, we are praying before the court to legislate, to create something that is not there in the rules.
Your Lordship, we contend that the Supreme Court would have the power to pass certain rules to the effect as they did back in 2013 with regards to the manner in which public interest litigations are to be listed, are to be scrutinized, and the costs that are to be imposed on petitioners for mala-fide petitions. Therefore, adding on to the rules already promulgated by the Supreme Court, we contend that the Supreme Court would have the power to establish a new set of rules to this effect, the effect of the prayer of the respondent, Your Lordship.
Please proceed.
With respect to issue number 2, Your Lordship, our primary submission is that a judicial impact assessment must be adopted as a mandate before the courts consider prayers for the enlargement of Part 3 rights. However, they must be conducted by the executive in collaboration with the judiciary. Your Lordship, I'd like to first establish what we mean by a judicial impact assessment. Judicial impact assessment was brought into Indian jurisprudence through the 2008 Task Force and the Salem Advocates Bar Association case, which essentially described judicial impact assessment as a process, as an assessment of the implications of legislations, the implications that these legislations would have on the judiciary in terms of the financial implications, the infrastructural implications, the personnel implications, and they envisaged this impact assessment to be conducted with regards to legislations. However, Your Lordship, considering the importance of the matter between us, considering the circumstances that we are in today, and considering the learned Attorney General's submissions as well, we believe that this definition of an impact assessment must be expanded to include within its ambit not just legislation, but also judicial pronouncements like the prayer before us, and also to not just assess the implications of the judiciary, but also the implications of the other organs of the state, since the enforcement of the rights is incumbent upon every organ of the state.
But counsel, just to flip the argument around from what we were asking the other side, judicial impact assessment requires not just domain knowledge, but also expertise in empirical research.
Yes, sir.
In predicting how statutory remedies will increase litigation rates, what sort of resource or personnel planning is required to meet it. So if you are trying to apply that framework or extend it backwards to fundamental rights adjudication, how do you expect, basically judges are also lawyers. How do you expect lawyers sitting in writ jurisdiction to have the same capacity?
Your Lordship,
Even the senior most judge in our apex court is unlikely to be an expert in those skills or methodologies which are needed for this sort of activity.
I understand your Lordship, which is why it is the contention of the respondent that this assessment must be spearheaded by the executive and the legislature with mere collaboration with the judiciary. The collaboration with the judiciary that we envisage is also envisaged by the 2008 task force, wherein it was recognized it mustn't be incumbent upon the judiciary to conduct statistical surveys and produce exact data as regards the infrastructure that is present to the judiciary, but the judiciary may assist, may advise the executive and the legislature in, yes, your Lordship.
The council deciding on the sanction strength of a high court is different from deciding on the scope of fundamental right.
I understand your Lordship.
So if fundamental rights are supposed to be moral commitments, right, should we even be considering the potential impact in terms of litigation rates, number of judges required? Aren't they two different things? That's the exact debate we were having with the petitioners.
We contend that it should be contingent on that, your Lordship. This is because we need to differentiate between short-term interests and long-term interests in the present case. While we deal with a short-term petition, certainly an impact assessment would to some extent delay the adjudication of the relief granted in the present petition. However, with the long-term interest in mind, your Lordships, a judicial impact assessment adopted as a mandate, as a thumb rule, would ensure that the time spent in litigation, that the amount of litigation and essentially the burden on the judiciary is reduced in the long term, because the distress or the causes of action that arise out of these expanded rights, which would be poorly enforced without an impact assessment, would increase manyfold if this impact assessment isn't conducted. And yes, your Lordship.
No. See, we have two questions. Okay. One is, in how many laws that the government floats, the parliament floats, this impact assessment is carried out?
I didn't understand the question. I'm so sorry.
You say laws to be flown, what impact it will have on litigation?
Yes, sir.
You are asking us to be aware of that, right? If you say something, just be aware of what impact it may have on the judicial assessment. When the government or the parliament, for that matter, frames laws, is such a similar exercise undertaken? Are you aware of that?
Your Lordship, it isn't been undertaken as of now, considering the fact that in the past, the courts and the various institutional authorities have only recommended it, and the center hasn't taken it up yet as a mandate. However, the center stands before this honorable court today, praying for the honorable court to recognize it, to be adopted as a thumb rule, as a mandate, so that from...
Just wondering, because you are asking us to do that, but when the government frames a law, is it being done? That's one question we have.
Yes, sir.
Second question is that you say, to be aware of the financial impact.
Yes, sir.
Right? The government has resources which are limited. In a country like ours, it's bound to be limited. We have one question. Suppose there is a report of starvation deaths.
Yes, sir.
And if the court says this should not happen, the government must do something about it. And it will be saying, let me find out whether I have money to feed people or not. No, right? So this is non-negotiable.
I understand.
Feeding citizens so that there are no starvation rates is non-negotiable. Government is not going to argue, we are sure and hope so, that we don't have enough money to cure this.
I understand.
Is this primary education for children also not very close to that? Is it also, can it not be seen as non-negotiable right? We understand there are many fundamental rights. We understand there are many limitations of resources. But is it also not something should be made non-negotiable, not linked to the resources part?
I understand, your Lordship, which is why it is a contention of the respondent that when a new dimension of Part 3 is being expanded, it is then that an impact assessment must be conducted. With regards primary education, your Lordship, the respondent concedes, and as my learned co-counsel will argue extensively, that the state does have a positive duty to ensure the education, the primary education of children between the ages 6 to 14. Therefore, in that context, the state isn't bringing the economic capacity argument. The economic capacity argument in the request for a judicial impact assessment only factors in when the prayer of the petitioner to expand the scope of Part 3 and recognize a new right altogether is considered. It is then that the impact assessment actually becomes relevant, your Lordship. Your Lordship, coming back to the reasons for why we contend that an impact assessment must be conducted. As I've argued previously, Your Lordship, and as again the 2008 task force has also recognized that the expansive interpretation of Part 3 and other constitutional rights of petitioners by the judiciary has been undertaken without an impact assessment to that effect, as a result of which there has been a manifold increase in the litigation before the judiciary, and that has overburdened the judiciary with caseloads and has essentially slowed the dispensation of justice. Your Lordship, we contend that this is exactly where an impact assessment steps in, and this is exactly what an impact assessment preempts, because an impact assessment aims to equip all the organs of the state with adequate resources to ensure not just the expansion, but also the practicable enforcement of these rights, thereby assuring that the distress of the causes of action that arise out of this poor enforceability are reduced, and this would naturally quicken the dispensation, the process of dispensation of justice, Your Lordship. Your Lordship, essentially on the basis of the above contentions, we argue that the judicial impact assessment must be adopted as a thumb rule, but it must be conducted by the executive and the legislature. In light of the paucity of time, Your Lordship, I'd like to request for an extension as per the court's discretion.
You already said 10 minutes.
All right. With your permission, Your Lordship, I'd like to move into issue number 3. Your Lordship, under issue number 3, our primary submission is that the scope of Part 3 extends to the children in the present case, but in a limited manner. Your Lordship, in the present case, I'd like to undertake a twofold establishment. First, I seek to establish the specific scope of Part 3, essentially to what extent do Part 3 rights extend to the children and to what classes of children do they extend. And secondly, if time permits, I'd seek to also establish how the state has fulfilled each of its duties and obligations under the article of the petitioner. With respect to scope, Your Lordship, with respect to Article 21, the respondents do contend the non-horizontality of Article 21. However, we take recognition of the fact that it has been held in the past that the state does have an affirmative duty to interdict and prevent any violation or exploitation of this right by a non-state actor. In the present case, it is clear to us that the dignity of these children has been violated by non-state actors, and therefore we do concede that the scope of Article 21 does extend to the children in the present case. With respect to Article 21A, Your Lordship, we concede the scope that Article 21A does extend to the children in the present case, but in a limited manner. And the limitation that I am seeking for, Your Lordship, is that this 21A right must only extend to primary education for those children within the stipulated age group of 6 to 14, Your Lordship. And lastly, with respect to Article 23, once again the state concedes that the scope of Article 23 would extend to the children in the present case, because the state does have an affirmative duty to interdict any exploitation of children, albeit by non-state actors like the organized gangs in this case, and therefore we do accept the fact that these 3 articles in a limited scope do extend to those children. Moving on to my second submission under this argument, which relates to the fulfillment of objectives, of duties and obligations by the state. Your Lordship, with respect to Article 21, the state has been held to have a duty to enable the access to right to life and pass suitable legislation, pass suitable policy frameworks, and essentially create suitable guidelines for the exercise of that right to life. In the present case, Your Lordship, we contend that the state has fulfilled its duties. Firstly, it has directed the police to conduct appropriate investigations and proceedings to ensure that the perpetrators of this exploitation of children are caught hold of. Secondly, the state has promulgated adequate legislations in the form of the Juvenile Justice Act, the Children's Act of 1960, and so on and so forth. And lastly, the state has acknowledged its various obligations in policies like the National Policy of Children 2013, Your Lordships. With respect to Article 21A, if I may take a mere perusal to a Right to Education Act under Chapter 3, as well as the various judgments to the effect of right to education, like Ms. Mohini Jain and Krishnan, it has been held that the state has a duty to enable the access to education in terms of infrastructure, personnel, finances, etc. Although the state does have a duty to ensure the compulsory admission and enrollment, it has to consider the multiplicity of factors that are there in the present case, specifically the individual circumstances and backgrounds of the children in the present case, as the learned justices have pointed out previously in this court. However, this issue will be dealt with in detail by my learned co-counsel. What I do seek to establish is that the state has fulfilled its duties in enabling the access to the right to education by firstly promulgating the Right to Free and Compulsory Education Act, which very comprehensively consists of the duties of appropriate government authorities to ensure the education of children between 6 to 14. Secondly, your lordships, with respect to the setting up of infrastructure to enable the access to the right to education, the latest UDISC Plus report of 2022 shows how over 74% of the total schools in the country are either government established schools or directly government aided schools. And lastly, your lordship, with respect to the financial commitments of the union to ensure that adequate finances are given to the essential topic of education, your lordships, the most recent union budget of 2023-24 showed almost a 17% increase in the budget that was granted to the Department of Primary Education. Your lordship, therefore, on the basis of the above, we contend that the state has fulfilled its duties of enabling an access to the right to primary education.
Council, just a last question from my side on this point. So even if the existing budget is considered, this case may involve arguments about the enrollment of a certain fixed number of children, where the budgetary commitment is going to be a small and minuscule portion of the existing budget. So are you actually seriously arguing that because there might be a minor addition to spending, we should assume that the government has done enough?
Absolutely not, your lordship. If I may answer.
If you look at the facts of the case, right, how many children are sought to be rehabilitated by the petitioner? Assume that their school fee is compensated by the state or they're enrolled in government schools. Relative to the spending on primary education, the amount is minuscule.
I understand a lot.
What exactly is the stance of the central government here?
I understand your lordship. The premise behind the contentions made by the learned council just now was just to show how the state has fulfilled its duties in enabling the access to education. As regards compulsory education and enrollment, as I established earlier, that there are multiple factors that need to be considered by the state when the compulsory education and enrollment is concerned. And this doesn't concern the financial capacity of the state, but more so the individual circumstances of these children. Yes, you're right.
Council, the moral question here is, even if the state develops subsidized housing, good public highways, good public schools, what is the state doing to ensure that the sections which are structurally excluded will also get access to these goods? Right.
I understand your
To say that we have good intentions, we have implemented our plans, we have developed resources is a good answer for the administrative state. But in judicial review, the question we are asking is, irrespective of the resource allocation and the planning by the administrative state, why are certain people still left out?
I understand your lordship, which is why we contend that when we talk about the compulsory education and enrollment of the children, in the present case, and the children who have been left out, who haven't been able to avail the benefits of the right to education, the union has taken into consideration and believes that it must take into consideration factors like the personal and individualistic circumstances of the children in the present case, specifically the fact that some of these children are not citizens of the country. Some of these children have been separated from their parents and families, and the fact that some of these children may have missed their primary education altogether and have crossed the threshold of the age of 14. Therefore, all the state is contending for is that instead of imposing a blanket requirement to ensure the compulsory education enrollment of all these children, which would involve the state to essentially pick up every single child on the streets, even against the will of him or his parents, and put him into primary schools. Instead of that, the union is basically contending that the circumstances of the children must be considered, and therefore, instead of imposing a blanket obligation of the state, the obligation must be fine-tuned to the individualistic needs of the children in the present case, Your Lordship. Okay. With that, I conclude my submission, Your Lordship. If the bench has no more questions for me, my co-counsel will be taking over the next two issues. Yes. It was a pleasure arguing before this honorable bench, Your Lordship. Please.
Greetings of the day to the honorable bench. If it may please the court, the council would like to begin with the submissions. I shall be addressing issue number 4 first and then moving on to issue number 5. Your Lordships, with regards to issue number 4, it is the submission at the very outset, the council would like to make it clear that the state does not contend the fact that these children are entitled to a right to education under Article 21A, given that the same has been inserted as a fundamental right through the 86th Amendment. Further, the importance of rehabilitation of children in such situations has been time and again highlighted by the Honorable Court, and the same is not contended by the respondent in the present case. Rather, what the respondent seeks to bring forth to the notice of the Honorable Bench is the fact that, as was also previously mentioned by my learned co-counsel, is the fact that we as of now do not possess clarity on, say, the number of children that may not be citizens, or as the Honorable Bench also pointed out, the fact that a lot of these The Moot proposition mentions that a lot of these children have been separated from their parents. A lot cannot be construed to mean every child in the present case has been separated from their parents. A lot of them may have been forced into such circumstances of having to beg on the roads, and they may, as the Honorable Court mentioned, they may still be with their families in the present case. In such an instance, Your Lordships, to mandate the state to put each and every child indiscriminately into primary schools without having regard to their individual needs and circumstances, that would result in the violation of them being able to continue existing with their families. Your Lordships, if I may direct your attention, one of the major principles underlying the Juvenile Justice Act and the rehabilitation scheme therein is the fact that regard must be have to individual care-based plans, as well as family-based care must be prioritized in the as per the rehabilitation scheme of the JJ Act. The primary objective of every child protection home under the Act has been held as first attempting the repatriation as well as the restoration of the children with their parents. Although the council understands that the right to education and the right to be repatriated or to be reunited with their family are not mutually exclusive, the council seeks to point out the fact that if we are to work with the assumption that each and every child must be put into primary schools indiscriminately, we would then be violating the wishes of their parents as well. Article 51A Clause K, Your Lordships, although is a fundamental duty not enforceable, recognizes the fact that the parents too have an obligation to ensure the education of their children. Your Lordships, the Honorable Court must pay regard to the fact that the wishes of a parent with regard to the trajectory of their education, or with the trajectory of their children's education, and in the manner it may proceed, must be taken care of in the present case. And the state, although has a duty to act as a guardian and custodian, cannot go beyond that step and disregard the views the parents may also have.
Counsel, sorry, please go ahead.
So if the parents wish that the children should have no education, what will prevail? The parents' wish or Article 21A?
Your Lordships, it is not the contention of the respondent that if the parents say that the child must not be educated at all, that the state may not intervene and do not provide education to the children. Rather, the manner in which they may receive education must be given regard to. The parents may wish for homeschooling, or they may wish for some other forms of education that they feel that the children are better suited to. In that case, the state cannot act as an arbiter and disregard the wishes of the parents.
Homeschooling is a tall order.
Sorry,
Homeschooling is a difficult concept in this scenario. But anyway,
I do understand that, Your Lordships, the state just wants to bring forth that the parents' wishes also be considered. In no way does the state contend that these children will not be provided their right to education. Rather, they are entitled to the same under Article 21A.
sorry.
But counsel, to reframe the same question with a more extreme case, assuming there are parents who don't want their children to go to school, assuming there are parents who put their children into trafficking, there are people like that. I think that's what the learned justice was asking you. What measure would prevail? Would the mandate of 21A apply even in those situations?
Yes, Your Lordship. In such cases, if, say, for example, in the present case, a lot of these children have been forced into prostitution. The Immoral Trafficking Prevention Act, the Learned Council will also be addressing the act in detail in the next issue. But for the purpose of this question, the Immoral Trafficking Prevention Act also lays down a provision where any individual that forces another individual, including children, into providing prostitution services, a forced prostitution for their economic benefit under Section 4 is also criminally liable to face punishment. Your Lordships, even Section 5 of the Act and the proviso to
That's a later question. I think the immediate question is that since the government is hesitating to commit to an expansive reading of Article 21A, which is what the petitioners have sought, your argument is there are complications, right? We are simply telling you, despite the complications, should we not side with the petitioners?
Your Lordships, with regards to the right to education of the children in the present case, it is not the contention that they should not be provided education at all. Rather, there are factors to be considered before such an extensive exercise is taken into account.
Counsel, this is what bothers us. The fact
Sorry,
is,
Lordships.
no, I'll point out. It wasn't as if your investigation or your work brought to light the problem. It was a private citizen working on their own initiative who brought the problem to light. You have made a persuasive case of what not to do, but show us what you have done to address the problem as it stands. And that is the concern for us, that there is no action, but you're still coming here and telling us, don't make us do this also. That is the problem that we have.
Your Lordship, with regards to the actions taken by the state, if I may direct your attention to a recent case of the Honorable Supreme Court.
Facts. Don't give me cases. What are the facts? What have you done?
Yes, Your Lordship. What I was trying to do by showcasing the judgment was the fact that in that case itself, the court recognized the fact that the National Commission for the Protection of Child Rights.
Still not getting to the point. What have you, as the state, done?
Your Lordships, in with regards to children in street situations, as in the present case, these children would come within the ambit of that definition. The NCPCR has laid down standard operating procedures with respect to their rehabilitation specifically, and the same have been undertaken by the state governments, which, in respect of this judgment, they filed affidavits as well with the Honorable Court.
That's all nice. That's all another country. What have you done?
Sorry, Your Lordship.
It's all very good. It's another country. What have you, as the government of Tim done?
Your Lordship, as we made to understand that the data of, as per the clarifications, the data of the nation of India applies mutatis mutandis to.
All of which is good. But tell us 3 measures to address this problem. If you haven't done, say that you haven't done. I just want to know that.
Your Lordships, in the present case, with respect to the affected children, specifically in the present case, the Commissioner of Police has taken cognizance and issued and conducted numerous raids, as a result of which multiple perpetrators of these organized crime brackets have been arrested, and legal proceedings for the same have been filed, and the state, in furtherance of that, continues to work for the benefit of these children. Your Lordship, further, with regards to the rehabilitation scheme as propounded by in the present case, it is also the contention of the respondent that the scope of the sort of rehabilitation that must be provided to the children must be established before an extensive right of rehabilitation can be passed as an expansion of Article 21 by the Honorable Court. It must be given regard to the fact that rehabilitation would work differently for different individuals in their times of needs. If we talk about rehabilitation given to bonded laborers, the kind of services they would require would be different. If we give regard to the rehabilitation provided to displaced persons, as say due to the construction of dams, as have come up before the Honorable Court previously as well, the kind of rehabilitation they would require would be different. So in the present case, it becomes really urgent and important that the Honorable Court, while passing any directions that it wishes to do so, defines the scope of rehabilitation that would be applicable to the current children in the present case, unique to their circumstances and their needs. Further,
You mentioned the readings that rehabilitation is not a constitutional right. Are you referring to a fundamental right or a constitutional right?
Your Lordships, it is not the contention of the respondent that although rehabilitation is not explicitly mentioned as a fundamental right in the Constitution, Your Lordships, the right in itself has been interpreted as being necessary to enable the enjoyment of the right to life of various individuals. Therefore, it would be simply untrue if the respondent is to stand here today and argue that that rehabilitation cannot be read in context of the fundamental rights. Rather, what the respondent merely seems to bring forth to the notice of the bench is the fact that it finds mention in a statute, which is the Juvenile Justice Act of 2015, and the scheme for the same is laid down under Section 53 of the Act. If I may also point out, Your Lordships, the council is not trying to abdicate the duty of the state in any way, but would just like to point out the fact that under Section 53 of the JJ Act, which lays down the rehabilitation scheme, institutions are mandated to provide rehabilitation with respect to that rehabilitation scheme. Such institutions are those NGOs or protective homes that may be registered under the Act. They do not necessarily need to be run by the state government, and the state would welcome even the role of non-governmental organizations in the same, given that the petitioner and their client, as they said in their pleadings before the Honorable Court, that they do feel really highly about the cause presented before the Honorable Court. The state would welcome any sort of help from their side as well with regards to their rehabilitation in the present case, given that it must be given regard to the fact that the state in itself has limited resources. Although the same cannot stand in the way of the enforcement of their obligation, it is just the contention of the respondent. The same must be given regard to ensure that to understand the reasonability of the way these rights can be enforced. Your Lordships, with the permission of the bench, one final submission under this issue is the fact that the right to education is espoused under Article 21A and the Right to Education Act, By a mere construction and a mere perusal of the Act, it is clear that the Act provides for primary education for children between ages 6 to 14. The Learned Counsel for the petitioner claimed Article 45 as well for children under age of 6 years as a matter of fundamental right. Although the counsel for the respondent understands the importance of early childhood care, which is why Article 45 was also amended to include provisions for early childhood care, and similar provisions also find place in the National Education Policy of 2020. It must also be brought to the notice of the court. The same cannot be enforced as a matter of fundamental right. The state does not deny the fact that these children may require early childhood care services and will do its level best to ensure that these children get the services they require for their overall growth and development. But to ask the same as a matter of fundamental right, to place Article 45 at the same level as, say, Article 21A, that would not be correct, given that, as per Article 37, directive principles are not enforceable in a court of law. Your Lordships, if I'm with the
Statement that you're making, this court has no power to give direction for enforcement of DBS. So rather, would you like to qualify it or?
Your Lordships, with respect to the same, it is not the submission of the respondent that by the written pleading of the respondent, what the counsel tries to convey is the fact that mere directive principles on their own cannot be justiciable in a court of law. Your Lordships, this was also held with regards to Article 41, which espouses the right to work for individuals. It was held that the right, or with regards to, for example, the Uniform Civil Code, as is mentioned in the directive principles, it cannot be held that the state can be called upon by the honorable court to enforce the same. Although the respondent does understand that a harmonious construction of directive principles and fundamental rights do place certain obligations on the state, and the state is not shying away from those obligations. But with respect to providing early childhood care as a fundamental right under Article 45, the same would not be justiciable on its own. With the permission of the
Counsel, why is that stance being taken? Because the moment you speak about dignity interest, which is attributed either to displaced persons or orphans, right, or any person who is in a situation of vulnerability, we are in a way opening up the interpretation of that right. And if some socioeconomic objectives are available to us in Part 4, why should we draw such a separation? Because if you look at the drafting history of Article 21A, it has come from such an articulation. The precise point which you were just making a few seconds ago, the harmonious interpretation of directive principles, especially with the open-ended rights. We've been reading about this now for 45 years. That's how social action litigation has grown. So why should we turn the clock back and not follow that model?
Your Lordships, the reason why the state brings forth this argument is the fact that when compared to the right to education, when compared to right to education, which is mentioned as a fundamental right under the Part 3 of the Constitution, when fundamental rights are being enforced, the state, it becomes incumbent on the state to ensure its fulfillment to its full. And when it comes to directive principles, the same are supposed to merely be guiding principles in the state making legislations and taking actions for the benefit of the country.
No, Counsel, this is a fairly outdated idea that Article 45 only requires the government to build up schools and colleges, whereas 21A is focused on the individual's right of access. In a way, if you think about the Right to Education Act, it only becomes possible when the two are read together, right?
Your Lordship,
the duty to supply and the right to access are linked to each other. The moment you separate them, they're not rights.
Your Lordship, if I may answer the question, with regards to the same, it is not the contention of the respondent that there exists no duty on the state to provide the early childhood care to children. The same would find a mention in the rehabilitation scheme under the JJ Act as well, as promulgated by the Parliament. In addition to that, it also finds mention in the recent National Education Policy of 2020. What the point that the Council is trying to highlight is the fact that the urgency that would be regarded to Article 21A, a similar urgency would then not.
Counsel, let me state it simply, since we are about to come to the end of our discussion. The argument about what a citizen is entitled to or what citizens' rights are cannot be disentangled from questions of state capacity. And your attempt to say that the directive principle should not have a bearing on how we read 21A is essentially making the same argument. That the aspiration for better state-run education is different, and the right of individuals from poor backgrounds or vulnerable backgrounds to access education is different. That reasoning is very dangerous, Counsel.
Your Lordship, the submission of
The next argument will be there is a duty to create courts and judicial infrastructure, but there is no right of access to bail.
Your Lordship, if I may, Your Lordship, the council does not seek to argue against the right to education of children in the present case. All the council seeks to highlight is that there is a constitutional mandate set for the same with regards to the age group of.
Council, your understanding of constitutional mandate seems to be that it's a limit. It's not. It's only saying prioritize. That's it. But that doesn't mean that the right to education of all children is not a fundamental right. The difference, like there was a right to education under Article 21 before Article 21A came into existence. There are a number of cases starting moving further back. What we are saying is that by putting in 21A, it was not the intention of Parliament to limit the fundamental right to education. And what my young brother has been pointing out is that 21A may only say this is where you must first focus on, but it is not saying no, there is no fundamental right to education vis-a-vis children below the age of 6.
Your Lordship, as the council would like to state, the state in no way will be abdicating its responsibility for education of children in general. As has been mentioned by the Honorable Court, the position of the state is to prioritize the education of those that fall within the ages of 6 to 14, so that their rights are adhered to, given that the primary education espoused in that article also states the same. It would not be arguing that other children who may not have received primary education, they shouldn't be given the same. If
Council, it's a very simple point made in the human rights literature that when you talk about third generation rights, neither are you limiting yourself to the idea of negative rights or positive rights. All rights have a combination of both elements. There is both a duty of restraint on the state and a duty to assist on part of the state, which makes a right meaningful, more so when it comes to socio-economic rights. But the center's stance, as evidenced in the submissions and your argument, seems to be contrary to that thinking.
Your Lordships, the state.
You're saying bring food grains, but that right of building food grain reserves is not connected to the right of the hungry person to receive the meal.
Your Lordships, I do understand that, as was said previously, the state will not be denying the right to education in any manner to children that don't fall within the same. It is a matter of prioritization of the children in the present case with regards to that age group.
Okay, perhaps we are going in circles. Please proceed.
If it may please the Honorable Court, I would like to move to the next issue. And if I may have an extension by this.
You will have
please,
10 minutes.
Thank you, Your Lordships. Your Lordships, with respect to issue number 5, the question of legalization of prostitution arises. As the petitioners have contended, they wish for a legalization of the prostitution in the nation. Your Lordships, if I may direct your attention towards paragraph 7 of the Moot proposition, where it is stated that the petitioners pray for legalization and regulation of prostitution. And in the same very line, they also mention how this would help children in the present case. Your Lordships, it is the contention of the state in the present case, the fact that many of these children have been forced into prostitution, have been subject to human trafficking, and are then being forced to render prostitution as a service to those people who engage in these trafficking rackets. Rather, the submission in the present case for the benefit of the children should be a more stringent application of the provisions of the Immoral Trafficking Prevention Act that provides criminal liabilities and criminal punishments against those that forcefully induce a person to engage in prostitution. With respect to legalizing of prostitution, Your Lordships, as was even pointed out by the Honorable Bench, there exists no express prohibition on the right to practice consensual sex work, which the Honorable Court has recognized as well in the judgment of Buddhadev Karmaskar. Your Lordships, the state in itself also does not contend the fact that it imposes any restrictions on an exercise of their right to profession under Article 19(1)(g) with respect to consensual sex work. However, Your Lordships, to construe the ITPA as a restriction on the same is not the correct manner to see the legislation in the first place, given the fact that the object of the legislation is to prevent immoral trafficking of individuals who are subsequently forced into prostitution. And the provisions of the Act lay down measures and criminal punishments for those individuals that do so. In no way does it restrict an individual to practice their consensual sex, their profession of sex work in the manner they will.
Counsel, what about dignity of work?
Your Lordships, as the Sorry.
their existence as human beings and being involved in some work that the state does not want to talk about? What about their other rights that are violated because they are not in a recognized profession?
Your Lordships, with respect to that, the Honorable Court itself, in the case of Buddhadev Karmaskar, recognized sex work as a profession. In addition to that, Your Lordships, the NHRC, which is the National Human Rights Commission, has also, in an advisory, recognized sex workers who engage in the profession out of their own will and volition as informal workers, thereby entitling them to benefits provided to such workers. This also included access to PDS services, which is the public distribution services. Your Lordships, an argument may be made that the right to food of these individuals is violated, given that they don't have access to government beneficial services. Your Lordships, in an order dated 2020, in 2022, under the title of Buddhadev Karmaskar versus State of West Bengal, the Honorable Court had listed down certain guidelines on the rehabilitation of sex workers who face sexual assaults in the process of carrying out their occupation. In doing so, Your Lordship said it had also asked the state governments to allow to provide these consensual sex workers with access to ration cards, given that they do not have access to proper identifications, which are essential for being provided these services. Your Lordships, the state governments in response have also filed affidavits to that measure, showing that ration cards have been issued even without proof of.
Mr. Counsel, I'm sorry to interrupt, but these are all things that the court has done or that another agency is doing. What has the state done? That is the question.
Your Lordship,
And what is the state doing?
Your Lordship, with respect to the rehabilitation, as was directed by in the Buddhadev Karmaskar case, the Honorable Court did exercise its Article 142 powers to issue guidelines. The state is ensuring compliance with those guidelines to ensure the better protection of sex workers. And further, Your Lordships, to prevent any violation of the rights by private persons, the ITPA is being applied stringently. Your Lordships, even in the present case, Section 5 of the Act and the proviso to the same lays down even more stringent provisions and stringent punishments when the person who has been affected by such immoral trafficking is a child or a minor. As is in the present case, Your Lordships, with respect to children in the present case, it is necessary to note the fact that these children have been forced into prostitution, and the fact that they are minors. They cannot consent to engaging in consensual sex work. Even when we talk about adult individuals consenting in sexual sex work, Your Lordships, their consent needs to be analyzed from a broader perspective. It is true it is also the fact that a lot of these individuals do not enter consensual sex work out of their own will and volition, but rather because of being forced because of lack of economical and educational resources. In doing so, Your Lordships, the consent as the way it's perceived needs to be looked at from a broader perspective and a broader lens. The fact that it cannot merely mean the fact that an external person is forcing them into engaging in such profession, but the fact that their socio-economic conditions place them in such a disadvantaged section in the society that they have to do so. In order to prevent such, when that happens, Your Lordships, these individuals are further vulnerable to private persons such as the organized crime gangs in the present case, to being subject to their victims. In order to prevent that, an implementation of ITPA becomes really important. Further, Your Lordships, with the respect of issuing guidelines, it is also important to highlight the fact that there is a certain degree of morality that comes into question with respect to this profession. Although the state, there exists, has been for a very long time, sex work as a profession has been seen one that is immoral. And morality, although may change, it cannot be said to, in certain respects, although morality will change over time.
Yourself. Whether you stay and say that it's the question of dignity, livelihood, it is not. You can't argue on one side that you're fully respecting what the courts have laid down over there and then get into this whole morality argument. You can't have it both ways. Either you say that you're opposed to what the courts have done over a period of time, or you are saying that what they have done is something that you will accept.
Your Lordships, the state is not opposed to the recognition of sex workers as. Your Lordship, to show the fact that
on many occasions the courts have found very problematic.
Your Lordships, it is not the contention of the respondent to showcase the fact that sex work cannot be recognized, given that it may be perceived as immoral in terms of public morality. Rather, the reason why the respondent brings this issue up in the present case is the fact that regard must be have to the sensitive nature of the matter. Although the Honorable Court is
as counsel for state, you need to be very clear with the line that you're adopting. I'm just reflecting on your argument. You go with a deed to the sub-registrar to get it registered. And the sub-registrar would have to elicit whether you are voluntarily signing and getting it registered. That's a requirement under the law somewhere. Now, you are registered as an advocate. There is a body which registers you, and there at least the question of whether you are being forced into it does not arise. But when you are registered as a sex worker, and if there is a registrar who has to elicit consent and who has to ensure that a person is not registering as a sex worker unless they are consenting, that would change everything, no? And if it is, I mean, with the hope that this is properly enforced, that would change everything, no?
Your Lordship, given regard to the fact that to equate forceful prostitution to maybe the undue influence when it comes to the signing of a deed, the same would not, the two things wouldn't bear a rational nexus to each other. Given the fact that in the present case, when you talk about consent of majorly individual, when you talk about individuals who are forced into sex work, their consent itself cannot be attributed to the fact that they may have undue influence only from private individuals. They may also be entering the profession because of the fact that they may have lack of economical resources or financial resources.
Per se, the question of consent is ruled out. For anybody who is working, I mean, you say people who are working as migrant labor, construction labor are consented to their work?
Your Lordship,
Exploitation. So are we going to construe consent in such a broad manner? Then the question of recognition of sex work doesn't arise at all.
Your Lordships, I do understand the fact that consent, when construed in such a broad manner, may also include implications with regards to individuals taking in other forms of labor. However, Your Lordships, as is presented by the facts of the present case, the vulnerability of these individuals is at a very higher pedestal compared to these in terms of the fact that when the respondent talks about consent being construed in a broader sense, the result of them being forced to take up sex work as a result of their economic constraints, the result ends up being the fact that they also become vulnerable to exploitation by these organized gangs. Your Lordships, although in the present case we're talking about children, but there exists a lot of adult individuals who may also be victims of these organized crimes, and the result would end up being the fact that if we are to just to show in clarification, Your Lordships, it is not the contention of the state that recognition of sex workers should not take place. Rather, the state is trying to inform the court of the fact that there is no express prohibition on sex work as a whole, and the state has not done same.
If 30 more seconds to wind up, you already have your extra time getting.
As the petitioners have said for the exercise of Article 142 in their written submissions by the Honorable Court to issue guidelines, Your Lordship, similar guidelines have already been enforced, laid down by the Honorable Court in an order dated 2022 in the case of Buddhadev Karmaskar, state of West Bengal. What the petitioners are seeking for is a remedy that has already been granted by the Honorable Court, and therefore the respondent would like to bring it to the notice that an exercise of this power would result in a redundant exercise with respect to the guidelines. Your Lordships, if it may please the court, would they want the respondent to state the prayers?
Thank you so much.
Right. Thank you so much, Your Lordships. It was a pleasure arguing before the bench.
Same here. Thank you. Yes, you would like to rejoin? Of course. Come on.
Your Lordships, a quick rebuttal on each issue in a chronological manner. Your Lordships, the respondents first bring in the issue of maintainability. Your Lordships, first thing that the issue of maintainability is not to be taken up before the constitutional bench. The matter has already been referred and a preliminary hearing has already been done. And second, Your Lordships, this issue is about the fundamental rights of even people who are inclusive of non-immigrants, of non-citizens of the state, Your Lordship. And that is why the petitioner has come before the Honorable Supreme Court and not the respective high courts of a particular jurisdiction, restricting the application of those fundamental rights to that particular jurisdiction, Your Lordships. On the first issue, Your Lordships, the respondents have failed to tell us as to how the intended objective of this court in dealing with frivolous PILs would be achieved if we go with generic cause titles of PILs, and publicity might still happen from other ends of, let's say, these people are still able to gain publicity from filing PILs by making their names known, and hence they were unable to tell us. Secondly, they are unable to tell us as to the impact that it would have on bona fide petitioners, the recognition that these people are getting, and the good and the advantage that is giving to the judiciary, to the society, to the marginalized people, and the ability of these people to gain resources and file these PILs in the first place. On the second issue, Your Lordship, firstly, the respondent has went out of the scope of the issue to argue that the legislature and the executive should step in and conduct a judicial impact assessment. Your Lordships, firstly, that would undermine the judicial independence and the judicial impact assessment in the first place, which they argue is to help the judiciary, would be purposeless, Your Lordships. They say that the judiciary would only remain to assist it. Your Lordships, in that case, the state should first ensure that they conduct a impact assessment on their legislation's end, and they ensure that they do not encroach rights in the first place to an extent that judicial impact assessments have to be carried out, Your Lordship. On the third issue, Your Lordships, they say that yes, we have given enough rights and we do not contest that rights exist, and we've also given the access. Your Lordships, they're not addressing the fact that when these rights are violated and children in the present case are unable to then approach and enforce their rights, what is the solution then? What is the state doing for these children? Your Lordships, the state has failed to take into consideration the gravity of the situation. These are children begging on the streets who are being given heavy narcotic substances, Your Lordships. They do not have their parents. They are being forced into begging, into prostitution. And the state says, we have given you rights, we have given you statutes, and we've ensured that certain access will be maintained. And they're not just 30 seconds to wrap up my rebuttals, Your Lordships, but they've not said that how the state is going to ensure that children, like in the present case, are going to be able to access these rights from the statutes that they've given. On the fourth issue, Your Lordships, they've argued that rehabilitation is not a constitutional right. Your Lordships, the petitioner has said that rehabilitation is not in its strictest sense, but in a sense where rehabilitation has to be construed, meaning that basic necessities are not being given to these children begging on the streets, Your Lordship. The duty of the state to give the basic necessity to its individuals is a constitutional duty of the state, Your Lordships. And on the last part, Your Lordships, they have not argued the issue that was present before this honorable bench, Your Lordships, which was whether this judiciary can intervene on the issue of legalizing prostitution or not, Your Lordships. They've not answered the question that the rights of these people who are engaging in voluntary sex works are being violated because there is a legislative lacuna, and they've not said as to why the parliament is in a better situation suitable to answer that question. Since my time is up, Your Lordships, I will stop.
Thank you so
Thank
much.
you. Smart.
Thank you, everybody. We have a right. Oh, they have a right of surrender. All right.
Lordship, if I may issue an answer to the rejoinder filed by the petitioners. Firstly, the petitioners contend that the respondents have failed to establish why a generic cause-based title would discourage frivolous petitions and encourage bona fide petitions. However, a mere perusal of our arguments, both in our oral submissions and our written submissions, show how we contend that a fastest filers first place an encouragement, place an incentive in that petitioners would have the intention of filing that petition first without conducting thorough and detailed research. And this incentive or this encouragement would, we contend, we submit, be removed if a generic cause-based title is to be followed. Your Lordship, and adding on to the petitioner's contentions, adopting a generic cause-based title in no form or shape does affect the rights of the class of persons that the petitioner seeks to enforce, and therefore does not really have a deterrence on the genuine and bona fide petitions that the petitioner espouses to represent. Secondly, with respect to the judicial impact assessment, Your Lordship, the petitioner contend that a JIA by the executive and the legislature would undermine judicial independence. However, a mere perusal of the separation of powers makes it very clear that the mandate, that the duty of provision of the very resources that we have brought within the mandate of a judicial impact assessment, the financial resources to the judiciary, the constitution of courts, and so on and so forth, is something that falls squarely within the mandate of the legislature and the executive. Furthermore, Your Lordship, it has been held that a very important factor of the institutional independence of the judiciary is that it mustn't be overburdened with caseloads, which is exactly what an impact assessment aims to preempt. And therefore, in that sense, Your Lordship, an impact assessment essentially upholds the independence of the judiciary as well as the doctrine of separation of powers enshrined under our constitution. Lastly, Your Lordship, the petitioners establish that the state has failed to comment on the actions taken by it in the present case. However, as my learned co-counsel argued extensively, that the state has directed the police to conduct its investigation and file its proceedings, and therefore the legal proceedings, the criminal proceedings are ongoing, considering the fact that this is a very important matter, a very widespread matter which has connotations throughout the city of Natchin, it is to be considered that the state would reasonably require some time for there to be materially observable benefits in the present case. Lastly, with respect to issue number 5, Your Lordship, the petitioners contend that the respondents have failed to comment on the subject matter of the issue, which was whether this is a policy framework. However, the primary submission of the respondent is that sex work is already legal under the current framework. Therefore, the petitioners make it unclear as to what they are seeking to legalize, as to what actually would or would not fall within the mandate of the judiciary and what would or would not fall within what they define as a policy matter, Your Lordship. With that, I conclude my rebuttals. It was a pleasure arguing before this honorable bench, Your Lordships. Thank you.
Thank you so much. We'll be rising.
Right.